Welcome back, everybody, to another deep dive. You guys have sent in so much about tenant rights in California.
It's amazing how much is out there.
It is. And it's so important for people to know, how to navigate this.
Oh, absolutely.
So we're going to do our best to break it all down and pull out the most important stuff for you. Like, did you know, starting in 2025,
oh, wow,
landlords are going to need photographic proof to take anything out of your security deposit?
That's a big change.
A big time. So let's get into it.
Definitely.
One thing that stood out to me was just how much California law seems to really protect tenants.
Well, especially compared to other states, California, it really tries to level the playing field between renters and landlords.
Okay, let's unpack that a bit. I mean, we know California has pretty strict eviction laws.
Uh-huh.
Can a landlord, just kick somebody out for any reason?
No, not at all. Evictions in California, they got to be justified.
Okay.
Which means the landlord has to have a valid legal reason.
It's like not paying rent?
Exactly. Not paying rent. That's a very common one.
Yeah.
But there are others too, like violating the terms of your lease or damaging the property or, illegal activities on the premises.
What about if the landlord wants to sell the property?
Right.
Or move a family member in?
Yeah.
Would those be considered valid?
So that's where it gets kind of interesting.
Okay.
Because California law, especially the Tenant Protection Act, it offers a lot of protection against these no-fault evictions.
Okay.
So even if a landlord has a reason like that, wanting to move in themselves,
yeah,
they often still have to follow strict procedures.
Oh, wow.
Which often includes providing relocation assistance to the tenant.
So even if they want to move in, they can't just give you the boot.
Not exactly. California law makes it really hard to evict tenants without a really, really solid reason.
Okay.
Especially those who've been renting for a long time.
So, okay, let's say a landlord does want to evict a tenant.
Right.
What would be the first step?
Well, they have to provide a written notice.
Okay.
And the type of notice depends on the reason for the eviction.
Okay.
If it's about unpaid rent, then the tenant would get a 3-day notice to pay or quit.
3 days. Got it.
Yeah.
What if it's not about rent, though?
Okay.
What if it's something like noise complaints or,
right.
Violating a pet policy?
Yeah, then it would probably be what's called a 3-day notice to cure or quit.
Okay.
Which means the tenant has 3 days to fix the problem or move out.
So these notices are like the first warning shot.
Yeah.
But it doesn't automatically mean you're out the door.
Exactly.
But you have the right to respond and say.
Yeah, you have options.
Okay.
It's important to know that.
All right, speaking of options, let's talk about rent control.
Okay.
How does that work in California?
So rent control basically limits how much a landlord can increase the rent each year.
Okay.
Statewide, we have AB 1482, which caps annual increases at 5% plus the local inflation rate.
Okay.
Up to a maximum of 10%. Right.
And this applies to most properties built before 2005.
So even if inflation is going crazy, my landlord can't just decide to raise my rent 20% next year.
Exactly. AB 1482 is there to protect you from those kinds of unpredictable, huge rent hikes.
All right, so that's statewide.
Yeah.
But some cities have their own, even stricter rules.
Absolutely.
Yeah.
You always want to check your local ordinances because they might be different.
Okay.
For example, Los Angeles has a rent stabilization ordinance, which actually limits increases to just 3%.
Wow.
For older buildings.
Okay, so rent control is helping to protect against, those big rent increases.
Yeah.
What about security deposits?
All right.
I mean, those can be a lot of money up front.
They can. But California has strict rules around those too.
Okay.
There are limits on how much a landlord can charge. 2 months rent for unfurnished units. 3 months for furnished.
Okay.
And there are actually lower limits for active duty military.
That's good.
You mentioned earlier there are some new rules coming in 2025 about security deposits.
Oh, yeah, that's right. Starting in 2025, landlords are going to need photographic evidence of any damage.
Wow.
To justify deductions from the security deposit.
So no more vague claims of wear and tear.
Right. They're going to need actual photos.
That's huge.
It is.
So it's going to be even more important for tenants to document the condition of the unit when they move in and out.
Oh, absolutely. Take photos, videos, whatever you need to create a clear record of the unit's condition.
All right. So we've been talking about what tenants need to know.
Right.
What about landlord responsibilities?
Well, California law also places significant responsibilities on landlords
Okay.
to maintain habitable conditions for their tenants.
So what does habitable, like, legally mean?
Well, it's really about the essentials.
Okay.
Things like structural integrity, a working water supply, plumbing, heating and cooling,
Sure.
ventilation, safe electrical systems, working appliances, pest control. These fundamental things that make a unit livable.
So if my heater breaks down in the middle of winter,
Yeah.
my landlord can't just ignore it.
That's right. They have a legal obligation to address these issues that impact habitability.
Okay.
And if they delay, you actually have some legal remedies available.
Like what? Can I, like, call a repair person myself and deduct the cost from my rent?
So there's a remedy called repair and deduct,
Yeah.
where you can, in certain situations, make necessary repairs yourself
Okay.
and deduct the cost from the rent.
Right.
But there are limitations, and you have to follow specific procedures.
Got it. Always document and proceed with caution.
Exactly.
Sounds like repair and deduct is pretty nuanced. So let's dive into that a little more.
Okay.
What kinds of repairs would qualify for this?
So generally, it has to be something that really affects the habitability of the unit
Okay.
and that the landlord has failed to address after you've notified them. So, for example, a leaking roof that's causing water damage or a broken heating system in winter, those would probably qualify. But, a chipped paint probably wouldn't.
Got it.
Yeah.
It has to be something pretty significant.
Right.
And what's the proper way to notify a landlord? Like, do I need to send a certified letter?
That certified letter is always a good idea because then you have proof that they got it.
Okay.
But at the very least, you should always notify them in writing.
Okay.
Clearly state the problem, give them a reasonable deadline to make the repair,
Okay.
and keep a copy of that notice for your records.
Okay, so written notice is key.
Yes.
What if they get the notice, but they still don't make the repair? Can I just go ahead and hire someone?
Well, not so fast. California has specific guidelines for repair and deduct. You'll need to familiarize yourself with those.
Right.
And it might involve things like sending them a second notice,
Okay.
saying that you're going to make the repairs and deduct the cost.
So there are specific steps. Sounds like this is where an attorney would be really helpful.
I agree. Having legal guidance can help make sure that you're following the right steps
Yeah.
and protecting your rights.
Okay, this is all super helpful information.
Good.
Let's switch gears a little bit now and talk about protection against discrimination.
Okay.
California has some pretty strong laws in place.
Yes, it does.
To protect tenants from discrimination. So break it down for us. What are some of those protected characteristics?
Well, the list is pretty comprehensive. It covers race, color, national origin, religion, sex,
Okay.
familial status, disability, source of income, sexual orientation, gender identity, and more.
Wow. Okay, so give us some examples of what would be considered discriminatory.
Okay. So, like, refusing to rent to a family with children,
Okay.
or charging higher rent based on someone's race or religion, or denying a rental application because they're using a Section 8 voucher.
Okay, so if I'm using a Section 8 voucher,
Yeah.
they can't just say no because of that. Okay, good to know. What options do tenants have if they believe they've been discriminated against?
Well, they can file a complaint with the California Department of Fair Employment and Housing.
Okay.
That's also called DFEH, or with the U.S. Department of Housing and Urban Development, which is HUD. And these agencies investigate these complaints, and they can take action against landlords who are found to be discriminating.
Good to know those resources are out there. What if a tenant reports discrimination?
Right.
And then their landlord starts, like, trying to make their life difficult?
Yeah.
Like they start entering without notice, or they try to find ways to raise the rent?
Yeah, that brings us to another really important protection for California tenants: protection against retaliation.
Okay, so landlords can't punish tenants for, like, speaking up about their rights.
Exactly.
Or reporting discrimination.
Exactly. California law says that landlords cannot retaliate against tenants for exercising those rights.
What are some examples of those protected activities?
So things like complaining about habitability issues, like we talked about earlier, or joining a tenants union, or filing a lawsuit against the landlord, or even withholding rent for the right reasons.
So if I complain about my broken heater and then they try to evict me, that could be considered retaliation.
Yeah, it could be, especially if it happens within 180 days of your complaint.
180 days?
Yeah, California law actually has like a presumption of retaliation.
Okay.
If certain things happen in that time frame.
All right. Landlords out there, take note. But what about a landlord's right to enter the property?
Okay.
They need to get in there sometimes for repairs or inspections.
Right. But even then, they can't just come and go as they please.
Right.
California law requires them to provide proper notice.
Okay, what is proper notice in California?
So for non-emergency situations, they generally have to give at least 24 hours written notice before entering.
24 hours, okay.
Yeah.
What about emergencies, though? What if there's a burst pipe or a fire?
Right. Well, there are exceptions for emergencies. Okay.
In those situations, landlords can enter without notice to address the immediate problem.
Yeah.
But it's still best practice for them to notify you as soon as possible.
So if my landlord wants to just come in for like a routine inspection, they can't just show up.
No. They got to give you that 24-hour written notice.
Okay.
And the notice should clearly state the date, time, and purpose of entry.
So it's all about respecting the tenant's privacy.
Yeah.
And giving them fair warning
Uh-huh.
what happens when a tenant moves out and leaves some stuff behind.
Right.
Does the landlord just get to keep it all?
Well, no, not quite. California law has specific rules about how to handle abandoned property.
So what steps does a landlord have to take?
They have to make a good faith effort to notify the tenant in writing.
Okay.
The notice should describe the property,
Mm-hmm.
where it's being stored, and how long the tenant has to claim it.
Okay. So they can't just immediately toss it.
Right. They have to give a reasonable opportunity to get their things back. What if the tenant never claims it?
It depends. The law has specific procedures for disposal.
Okay.
And they kind of vary depending on the value of the items.
Right.
They might be able to sell valuable items to cover things like unpaid rent or storage costs, but for lower value items, they might have to donate them.
All right, so there are even rules for abandoned property.
Yes,
Wow. It's clear that California takes this seriously.
it does.
Are there any other important disclosures that landlords have to make to tenants?
Yes, California law really prioritizes transparency in the rental process.
Okay.
So landlords have certain disclosure obligations.
Like what kind of things?
Well, besides like the basic terms of the lease,
Yeah.
they have to disclose things like whether utilities are included or if the tenant's going to have to pay for water, trash, or gas separately.
Okay. That's good to know up front.
Yeah, another important one is about any known issues with the property,
Okay.
particularly if there's a history of mold.
Mold can be bad news.
Yes, it can.
So if the landlord knows there's been a mold problem,
Yeah,
they are legally obligated to disclose that.
absolutely. Tenants need to be informed about these potential hazards.
Right.
So they can make a good decision.
Okay, so mold is a big one. Any other potential hazards that they have to disclose?
Yeah, they also have to disclose the presence of lead paint
Yeah.
or other hazardous materials,
Yeah.
especially in older buildings.
So a building was built before lead paint was banned. They got to let me know.
Exactly.
But-
Transparency and safety.
Okay, what happens if a landlord doesn't make one of these disclosures?
Well, it really depends on the situation and what information wasn't disclosed.
Okay.
It might give the tenant grounds to break the lease without penalty,
Oh, wow.
or in other cases, they might be able to sue the landlord for damages.
So it's important for tenants to know their rights
Yes,
and to speak up if they think something's not right.
absolutely.
We've covered a lot of ground today.
We have.
And it's clear that understanding your rights as a tenant in California is so important. We're going to continue our deep dive after a short break.
Welcome back to our deep dive into California renter rights.
Okay, so we've laid out like the legal foundation,
Mhm.
but let's get practical. What are some like common situations where tenants might actually need to assert these rights?
Well, one we see a lot involves repairs.
Okay.
You know, like let's say the landlord is dragging their feet on fixing a leaky roof.
So I've sent my landlord a written notice about the leak,
Right.
like we talked about, but they're ignoring me.
Okay.
What's my next move?
Well, first, documentation is key.
Okay.
Take photos or videos of the damage.
Uh-huh.
Keep copies of any communication you have with the landlord.
Yeah.
Write down dates and times of conversation so you have this paper trail if you need to escalate things.
So document everything. But what if they still ignore my requests?
Okay.
Can I like withhold rent at that point?
So withholding rent is a powerful tool, but there are rules.
Okay.
In California, you can withhold rent if the issue affects habitability, but you need to follow a specific procedure.
So it's not just a free pass to stop paying.
No,
Well,
definitely not.
okay.
You need to notify your landlord in writing about the problem.
Uh-huh.
Give them a reasonable opportunity to fix it.
Okay.
And if they fail to do so, then you can deposit your rent into an escrow account.
Okay, so that shows that I'm still going to pay.
Exactly. It shows good faith
Yeah.
that you're willing to pay once the issue is resolved.
Right. It's much more formal than me just like holding on to the money.
Right. It shows that you're not trying to skip out on rent.
Right.
You're just holding it in trust until they fulfill their end of the bargain.
Okay, so I've documented everything, notified the landlord, and they're still not fixing the roof.
Okay.
I'm ready to withhold rent and set up this escrow account.
Right.
How do I do that?
Well, it's best to consult with an attorney or a legal aid organization.
Okay.
They can help you navigate that process
Okay.
and make sure you're doing everything legally.
That's where having that legal assistance can be so helpful.
It really can.
Okay, so besides repairs, what other issues come up a lot?
Well, security deposit disputes are another big one.
Ugh. It seems like it happens all the time.
It does.
You move out and the landlord's like, "Oh, there's damage everywhere.
Exactly.
You're not getting your deposit back."
Classic move.
Yeah.
But remember, California has those strict rules about security deposits.
Right.
They can only use it for unpaid rent.
Uh-huh.
Tenant caused damage beyond normal wear and tear
Right.
or cleaning to restore it to move-in condition.
Okay, let's say they claim there's damage, but I disagree.
Right.
What can I do?
Well, as we've been saying all along, take photos and videos.
Okay.
When you move in and when you move out.
Right.
That documentation is your best defense.
Okay.
If you disagree with a deduction, write a letter to the landlord,
Uh-huh.
explain your position, and provide evidence to support your claim.
So if they try to charge me for a stain on the carpet that was already there
Right.
and I have photos, that's good.
Yes. Visual documentation can be very persuasive.
Okay.
And don't forget, starting in 2025, they also need photos.
That's right.
So make sure you're taking them too.
Document.
It's your mantra.
Okay, let's switch gears again and talk about eviction.
Okay.
What happens if a landlord files an unlawful detainer lawsuit?
Okay, first, don't panic.
Right.
Just because you get a summons and complaint doesn't mean you're automatically evicted.
Okay.
You have the right to fight back.
Okay, so should I get a lawyer?
I highly recommend it, yes.
Okay.
Especially if it's complicated or you think it's unjustified.
Okay.
An attorney can help you understand your rights, prepare a defense,
Uh-huh.
represent you in court.
Okay, besides saying I paid my rent,
Mm-hmm.
what are some other common defenses?
Well, one common defense is that the landlord didn't follow product procedure.
Oh.
Like they didn't give you the right notice
Uh-huh.
or didn't wait long enough before filing the lawsuit.
So if they mess up the paperwork, that can help me.
It's possible. It depends.
Okay.
That's why it's important to have an attorney review everything.
Okay, what are some other defenses I might have?
Another one is that the violation was minor
Okay.
or that you had a good reason for not complying with the lease.
Okay.
Like if your lease says no pets, but you were temporarily caring for a service animal,
Okay.
that could be defensible.
So there's some nuance?
Every case is unique.
Okay.
It all depends on the facts and how you present your defense.
What if the landlord does have a good reason for the eviction,
Okay.
but I just need a little more time to find a new place?
Right.
Is there any way to delay things?
You might be able to negotiate a move-out agreement with the landlord.
Okay.
It's a good option if you're willing to leave,
Uh-huh.
but need a little more time.
So instead of fighting it out in court, I can try to make a deal.
Exactly. And an attorney can help you negotiate that agreement
Okay.
and make sure it protects your interests.
So I still have options,
You do?
even when facing eviction.
Yes,
California law really tries to protect tenants.
it does. But you have to be proactive and informed to take advantage of those protections.
This is all incredibly helpful. It's clear that understanding your rights
Yeah.
can make all the difference.
It really can.
Stay tuned for the last part of our deep dive, where we'll explore even more resources
Great.
and strategies for California renters. All right, welcome back to our final part of this deep dive on California renter rights.
We've covered a lot, but
Yeah,
knowledge is only powerful if you know how to use it.
exactly. So let's talk strategy. What are some proactive steps renters can take to protect themselves and avoid problems?
Well, first and foremost, read your lease agreement carefully.
Okay.
I know it can be a lot of legal jargon,
For sure.
but understanding the terms is so important.
So don't just skim it and sign.
No, definitely not. Pay close attention to the rent amount, how long the lease is, the rules about pets and guests and noise, and the procedures for repairs and giving notice.
It's a contract. It's serious.
It is.
What else? What other proactive steps?
Well, as we've been saying all along, documentation is key.
Document.
Exactly. Keep really good records of everything.
Oh.
Rent payments, repair requests, any communication with your landlord.
Okay.
And the condition of the unit when you move in and out.
Photos and videos, your best friend.
Absolutely.
Yeah.
Especially if a dispute comes up later.
Yeah.
Visual proof is really helpful.
What about communicating with your landlord? Any tips there?
Yeah, communicate in writing whenever you can, even if you've talked about it on the phone.
Okay.
Emails or texts, create a record that can be helpful.
Right.
And be polite but firm.
So no angry late-night texts about the broken disposal.
Probably not the best strategy.
Okay, keep it professional.
Yeah.
All right, so read the lease, document everything, and communicate in writing.
Exactly.
Those are good tips.
Yeah.
What happens when a problem does come up, though?
Right.
Where can tenants go for help?
So we mentioned some resources earlier, but the California State Bar website is really good. They have all kinds of guides and fact sheets and even sample letters for tenants.
So, like, I could find a template for those written notices we talked about.
Yes, exactly. And there are also a lot of legal aid organizations throughout California.
Go.
They offer free or low-cost help.
That's great.
They can give you advice, help you negotiate with your landlord, or even represent you in court.
So even if I can't afford to hire my own lawyer, I can still get help.
That's right. And don't forget about tenants unions.
Oh, right.
They often have resources and support, too.
So there's like a whole network out there.
There is.
It's just about finding it.
Exactly. And remember, being informed is your best defense.
Right.
The more you know about your rights, the better.
This has been so informative.
I'm glad.
I feel like we've really covered so much.
We have, from evictions to rent control to security deposits to repairs.
Yeah, and even practical scenarios and resources.
It's a lot to know, but it's important.
It is. California really seems to have this system in place.
It does.
To protect renters.
It does. But you have to advocate for yourself.
Okay.
And understand your rights.
That's the key takeaway here.
It is. Your rights matter, and California law is there to support you.
Absolutely. Don't be afraid to stand up for yourself. Seek help when you need it.
Yeah, good advice.
You're not alone out there.
You're not.
Thanks for joining us on this journey through the world of California renter rights.
Call now 714-442-9741. Thank you.